to winning isn't easy. Buyer's remorse. Can you change your mind about terminating your employment and entering into an ERISA settlement? Once you file a lawsuit in federal court to get your ERISA disability benefits, the court's going to set a settlement conference, which is known as a mediation. The purpose of the mediation is to settle the outstanding issues and avoid having the court making a decision on your case. Now, in mediation, you're supposed to have control, if you will, over the results of the litigation. And it is led by a neutral third party who's called a mediator. The mediator is subject to the rules of ethics and isn't supposed to pressure or threaten any party in an attempt to resolve the case. But what also happens is that the mediator is going to, most likely, as part of the mediation process, be presenting you with a release that the disability carrier wants you to sign, and sometimes the employer wants you to sign. And in that release, you will be giving up your vested ERISA disability benefits, such as life insurance, your short and long-term disability benefits, your group insurance. And the employer might also be asking you to sign a severance agreement as part of this litigation. Now, your employment status really shouldn't have much to do with your ERISA disability claim. It should be subject to a completely different process and a different type of agreement, which that agreement should be taking into consideration the impact of that severance agreement on your ERISA benefits, as I spoke about in an earlier segment. So what happens in the course of this mediation if the mediator violates the rules of ethics and pressures you to enter into a settlement and sign a severance agreement? Can you have buyer's remorse? And I'm going to tell you the unfortunate story of Karili Zahares. His disability claim against Hartford was denied, and he filed a suit seeking the reinstatement of his long-term disability benefits. The mediator, who's supposed to be a neutral third party, was appointed by the court to assist the parties to reach a settlement. And allegedly, during the course of the mediation, the mediator pressured him into settling the case and insinuated that if he didn't settle, Hartford would continue its surveillance. Now, Hartford is well known in the ERISA world for its surveillance tactics. And during the mediation, the settlement was reached and the court entered an order dismissing this action without prejudice. And the parties ultimately indicated that the settlement would not be if it wasn't consummated within 60 days, that the parties could move to reopen the action and restore it to the calendar under the federal rules of civil procedure 60B. Now, the court would retain jurisdiction to enforce the settlement. If in that 60-day period of time, Zahares had second thoughts, didn't like the settlement agreement, didn't like the resignation requirements or anything about this agreement, he could have come back and said, timeout. But Zahares cashed the settlement check, and the parties ultimately filed a joint stipulation of dismissal with prejudice. Now, several months later, he moved to reopen his case and set aside the previous judgment on the basis of the mediator's misconduct that had led him to accept what was now an unfavorable settlement agreement. So let's talk about Federal Rule 60B and mediator misconduct. Rule 60B permits a court to relieve a party from an order on the grounds of mistake, inadvertence, and excusable neglect, newly discovered evidence, fraud, or any reason that justifies the relief. This remedy is an extraordinary relief and can only be invoked upon a showing of exceptional circumstances, including fundamental injustice. You have to show three things to win this motion. You have to show a meritorious claim or defense. You have to show that the alleged misconduct has to be proven by clear and convincing evidence, and the misconduct would have prevented you from fully presenting your case. And after proving those three things, the court then has to balance the competing policies favoring the finality of the judgment and justice being done in view of the facts to determine within its discretion whether the relief that you've sought is appropriate. Now, just by me going through these elements, you understand this is an incredibly high burden. Ultimately, this case ends up in the Fourth Circuit. And what did the Fourth Circuit do? They ruled that There was no extraordinary exceptional circumstances under the federal Rule 60B that would allow him to reopen his case. The court reasoned that he had knowledge of the mediator's alleged improper conduct at the time he settled the case, that he had 60 days in which to reopen the case if he chose not to consummate it. And he chose to go forward with this settlement by cashing this settlement check and by agreeing to a joint order of dismissal. And then, of course, he waited over a month after the expiration of the 60 days before having buyer's remorse. And ultimately, the court said, look, we don't really understand why the threat of further surveillance would have caused you to settle this case prematurely. And so we don't get your whole argument regarding the impact of the mediator's statement about possible surveillance. So you can see there was a lot of reasons why the court was not going to allow the claimant in this case to repay the money and reopen his case. Now, I will tell you, having attended thousands of mediations, if the mediator's conduct was improper, you can say, wait a second, we're going to terminate this mediation. I want a new mediator. I'm going to file a grievance against the mediator based on the conduct. I'm going to ask the court to appoint a new mediator. And if you negotiate a settlement at mediation and you're having buyer's remorse, you should file that motion within 60 days to reopen and explain how the mediator's threats led you to enter into this settlement and why the threats were the motivation for you to do something that you wouldn't have done. If you've got the check, you should return the check and you should refuse to sign the stipulation. All of this lack of action and the timing of the lack of action was really detrimental to him. The better thing, quite frankly, is not to have buyer's remorse. The better thing is to understand that when you're entering into a mediation, as part of that mediation agreement, you're going to be asked to sign a general release. And that release is going to be giving up your rights, including your rights to disability benefits, your rights to life insurance, potentially through that particular carrier. And you may be asked to sign an employer's severance or termination agreement. If that happens and you're presented with all of that, there's a timeout. The employer should not be presenting you with that sort of stuff at an ERISA disability mediation, and that's a cause to stop and pause the mediation. You don't want to let yourself get caught up or set up in this type of situation. Better yet, you should be prepared, you should be represented by counsel, and you should be understanding the rights and obligations you're giving up, because buyer's remorse, quite frankly, won't fly in federal court. Got it? I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please like our page, send us a review, share it with your family and friends, and please subscribe to this podcast. That way you're going to get notice every time a new episode comes out. Thanks, and we look forward to having you tune in next week's episode of Winning Isn't Easy.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.